Just so you know, this show is about scary stuff. So don't say I didn't warn you guys. And remember, don't be scared.
Episode 123, Fallen Idol and Trying to Take Charge. War Baby here with another episode of Murderous Minors. This week on Murderous Minors, we're going to look at several cases, so let's get started. And yes, 14-year-old alleged Garland, Texas Texaco shooter Abel Acosta is still on the run. If you're a frequent listener of the show, you know it's called Murderous Minors, but we talk about all kinds of cases where minors have killed someone, including accidents, like our first case this week. Did any of you watch American Idol last year? Because just recently, a contestant from that season was involved in a deadly car accident. On February 8, 2022, 54-year-old Larry Parris was killed at his own home in Pacolet near Spartanburg, South Carolina, when the 2011 Ford truck that former American Idol contestant Caleb Kennedy was driving barreled into him. Kennedy, who was 16 years old on the show, made it to the top 5 in the competition before an old video clip resurfaced and caused him to leave Hollywood and return home to Roebuck, South Carolina. In the years-old clip, a then 12-year-old Kennedy is seen sitting next to another kid who's wearing what most assumed was a KKK hood. The video was shared around Dorman High School, where he was a sophomore, and eventually made its way to social media. Kennedy's mother spoke out, saying that it was meant to resemble what was worn in the 2018 film The Strangers Pray at Night, and thought that a jealous classmate was the likely instigator. He exited the show in May 2021 and made a statement apologizing for the incident 6 weeks later, and he didn't make the news again until word of Larry Parris's death hit the news 8 months after. According to the arrest warrant, Kennedy is alleged to have met a friend at a Walmart where he took what he said later was a, quote, deep hit from his friend's THC vape pen. According to the state, Kennedy was headed to his girlfriend's house in Union, South Carolina, about 25 miles away, at around 12:30 on Tuesday, February 8, 2022. He headed down Southport Road but eventually veered off and traveled northbound on private West Murph Road for about 175 yards. Kennedy had deviated from the main roadway and had driven onto the Parris property, striking Larry Parris, who was standing in his driveway talking to his best friend on the phone. The truck ran over the man, pulled him under the truck, and dragged him into his own garage workshop, where the nightmare came to a crashing halt when the truck hit the wall. Parris's wife of 35 years received a call from Larry's best friend who told her to go check on him because, quote, something just happened. His daughter later said that they ran into the garage and saw the chaos and a stranger who was out of his truck just standing there. She dialed 911 and tried to get her father to speak to her, but he couldn't. Kennedy is heard on the 911 call saying that he's sorry. 54-year-old Larry Parris was transported to Spartanburg Regional Medical Center, where the dedicated husband, father, and avid outdoorsman was pronounced dead at 3:45 p.m. Kennedy was also taken to the hospital, but was released with only minor injuries. It was reported that he had also just recently doubled his dose of the antidepressant Prozac. Kennedy was arrested at 7 p.m. and charged as an adult with felony DUI resulting in death, and the next day, the teen was in court where he apologized through his attorney, who said that, quote, he is absolutely so sorry for what happened, adding that Kennedy isn't a flight risk. He was denied bond for the first time and returned to Spartanburg County Detention Center. At Kennedy's second bond hearing 2 weeks later, his defense attorney requested bail be set at $20,000 plus house arrest with an ankle monitoring device. The teen openly wept when Parris's wife and daughter spoke, with his daughter saying, quote, if I have to relive that every day for the rest of my life, please explain to me how he even has the opportunity to see the light of day ever again. He should have to sit there. We request that bond be denied. The judge apparently agreed and denied bond again, this time pending complete toxicology results from SLED, the state law enforcement division that we talked a bit about in the episode about the murder of James Jordan, Michael Jordan's father. SLED is backed up for months, according to Kennedy's defense attorney, who said, quote, he just barely turned 17, Judge. This could be months and months before we could get back in court, and there are much more egregious cases than this on a felony DUI that are given bond. It's unfair to this kid to be sitting in jail for months on a backlog with SLED. I'm standing up just saying a bond should be set today. It's ridiculous. Just because they don't have their act together should not penalize us. He also said that Kennedy had said at the scene that he was, quote, fucked up, that he was tripping. He had a bad reaction, referring to the teen as disoriented at the time of the crash. The bond hearing was continued pending the blood results, and the judge also granted a motion filed by the state to access Kennedy's medical records. 2 weeks later, on March 10, 2022, Kennedy was in court for the third time for an emergency bond hearing requested by his attorney after he submitted medical records to the court showing that there was THC in the teen system, but there wasn't any alcohol. Larry Parris's widow spoke, saying in part, quote, the only reason we're here is because this man made a conscious decision to put something into his body and then consciously got into a vehicle knowing he didn't need to be driving and came down a dead-end road and came into my driveway. I don't think he should be allowed to get out and take a chance of doing that to somebody else. Parris's daughter said, quote, Judge, I have to relive that day every day for the rest of my life. Please explain to me how he has the opportunity to go home. Nothing's changed between February 8th and today, so why are we even here? Kennedy's attorney pointed out that his client was in virtual court that day in a yellow jumpsuit instead of orange because he was on suicide watch and was still disoriented. He said that, quote, Caleb is a minor and the jail wants to give him more Prozac, but he's still having the same symptoms that are described at the scene of this accident. Blacking out, dizziness, and his family, they're obviously worried. Unfortunately, Caleb is now on suicide watch at the adult jail and he is only a 17-year-old minor with no criminal record whatsoever. He also continues to exhibit the same symptoms of blackouts and dizziness while in jail that he exhibited at the time of the accident. Caleb is clearly being treated unfairly and it's ridiculous in my opinion. The judge again set no bond, saying without the complete toxicology report as requested by the previous judge, the conditions previously set forth had not been met. He ended the hearing with, quote, nothing has changed. Those conditions have not been met. There hasn't been a change in circumstances, so I'm not going to go any further with this bond hearing today. Kennedy's attorney said following the hearing that, quote, we provided the court with blood and urine results which showed the presence of THC, which is what the state is alleging is the illegal influence, so what else do they need? That is why the previous judge's ruling makes Caleb's situation so frustrating. This means there is no foreseeable date for a bond. Caleb Kennedy remains in the Spartanburg County Detention Center, with his initial appearance set for April 14, 2022. He faces up to 25 years in prison. Now on to Iowa, where 2 weeks before Halloween 2021, on October 14th, a 911 call came in to Cedar Rapids dispatch at approximately 2:10 a.m., reporting suspicious noises coming from a home on the 300 block of Carnaby Drive. When officers responded, they encountered a completely bloody 17-year-old Ethan Alexander Orton sitting outside of the home, and he told officers that he had, quote, killed his parents. Just inside the house, in the living room, police located the stabbed and slashed bodies of Orton's mother, Misty Scott Slade, and his 42-year-old father, Casey Arthur Orton. The criminal complaint indicates that the teen not only told the responding officers that he'd killed his parents by stabbing them, but later at the police station also described returning to his wounded mother with an axe when he realized his initial attack with the knife hadn't killed her. Both were employees of local dealership McGrath Auto, where Misty had just recently started working, but where Casey was a loved service technician, remembered for his passion for mentoring younger mechanics with patience and enthusiasm. Neighbors called them kind, caring, and friendly, and said that an older daughter used to live there as well but had graduated and moved out on her own. Orton was taken into custody and charged as an adult with 2 counts of first-degree murder, and his bail was set at $2 million at his initial appearance. His charges were direct filed to adult court. He was placed in the Lynn County Detention Center and was in court on November 29, 2021, where he pleaded not guilty to both first-degree murder charges. 2 weeks later, on December 13, 2021, Orton's attorney filed a motion to have his client undergo psychiatric examinations, alleging that the teen has a, quote, mental impairment or disorder. A competency hearing was scheduled for the following month, and at that hearing on January 14, 2022, it was determined that Orton was able to understand the charges against him and aid in his defense, and was indeed competent to stand trial. It was scheduled to begin on February 8, 2022, but Orton's defense team sought a delay, which was granted on February 4th. His double murder trial is now scheduled for October 18, 2022, just over 1 year after his parents' murders. Ethan Orton remains held at the Lynn County Correctional Center in Cedar Rapids, Iowa, on $2 million bond. If you pay attention to sports, you may have heard rumblings of a new counterculture that's begun there. Athletes caring for their mental wellness and the critical link to their performance. You don't have to be an elite athlete to experience external stressors of all forms coming at you from every angle, but I just want to tell you that managing stress is easier than you think, and Noom Mood can help teach you just how to do it. Whether it's repetitive daily stress that you've come to expect or the anxiety that anticipating it can cause, Noom Mood can give you the tools you need to take the journey to mental wellness one step and one day at a time. You're guided every step of the way, and you'll be assigned a dedicated coach whose goal it is to be your support. My coach Madeline already has me thinking more about better self-care and about the other goals I set when I started Noom Mood. Don't let stress get the better of you. Just let the behavior change experts at Noom help you help yourself, just as they've helped millions of people through their weight loss app. Worry less and feel happier. Sign up for your trial at noom.com/warbaby. That's NOOM.com/warbaby. And there's more news out of Iowa, this time involving the murder case of Nohema Graber that we've previously discussed in episodes 115 and 118. If you'll recall, the 66-year-old Fairfield High School Spanish teacher from Fairfield, Iowa, went missing following her usual after-school walk in Chautauqua Park on November 2, 2021. She was reported missing the following day after her family noticed that she didn't come home the night before. Ultimately, 2 of Mrs. Graber's 16-year-old Spanish students were arrested for her murder after her beaten body was found hidden under some random items in the wooded area of Chautauqua Park. The last time we talked about 16-year-olds Jeremy Goodale and Willard Miller, they were trying to get their cases sent back to juvenile court, and there have been 2 further hearings since then. On Monday, March 21st, 2022, both Goodale and Miller's defense attorneys argued before the court to ban the media and any outside spectators from the teen's reverse waiver hearing, scheduled for 3 days later, on Thursday, November 24th. The hearing was set to determine whether Goodale and Miller's cases will be sent back down to juvenile court as they've requested. Since first-degree murder is a forcible felony, they were automatically charged as adults per Iowa law. Additional documents and warrants were unsealed by the judge, alleging that the Snapchat messages that law enforcement's tipster showed them revealed the extent of Goodale's involvement, which until now had remained a bit unclear. They clearly show that he was actively, quote, involved in the planning, execution, and disposal of evidence related to Nohema's death. Miller and Goodale planned this murder and discussed its aftermath over Snapchat. Those messages also indicated that Mrs. Graber had been beaten to death with baseball bats. Video footage from the day of the murder showed her arrival at Chautauqua Park and her car then exiting the park after almost 45 minutes, being followed by a Ford truck. It's also alleged that Goodale returned to Snapchat following the murder with detailed information about the crime, like where Mrs. Graber and her car were located, and how she was murdered, and where they stashed evidence. Warrants show that 2 baseball bats, clothing, towels, and hair were taken from Goodale's home the day after Mrs. Graber's body had been found. Court documents also show that Goodale told Iowa Division of Criminal Investigation agents that he'd pushed a wheelbarrow from his home to the scene of the murder at about midnight on November 2nd, nearly 8 hours after Mrs. Graber was killed. A witness had told police that he'd seen someone pushing a wheelbarrow toward the park at that time, according to the warrant, and a wheelbarrow was one of the items used to conceal Mrs. Graber's body. The state said in opposition to the defense motion that, quote, the defendant, in effect, is requesting a secret hearing to present confidential evidence as to whether the remainder of his first-degree murder trial should be held behind closed doors. This is not in keeping with the principles of the American justice system, and his request should be denied. According to the defense attorneys, closing the hearing to the public would act to help preserve their clients' reputations, with Miller's attorney adding that, quote, this isn't a request for a secret trial. This is a request to keep protected information protected. Additionally, statements of either defendant that might be protected by both the Fourth and Fifth Amendment are potentially evidence within that hearing. The defense wanted a decision on a motion to suppress evidence to be ruled on prior to the reverse waiver hearing, where the issue was supposed to be addressed. However, the judge determined that wasn't necessary. And though the defense also worries that releasing even more information to the public can potentially taint the jury pool, all of the defense team's requests were denied, and the March 24th reverse waiver hearing remained scheduled and open to the press and the public. The following day, Wednesday, March 23rd, Miller's attorneys filed appeals to the Iowa Supreme Court alleging that, quote, despite clear constitutional concerts with evidence gathered in this case, the state indicated intent to use challenged evidence against Miller in the reverse waiver hearing scheduled March 24th, 2022. The district court hearing denied Miller's request to address suppression issues prior to reverse waiver hearing, creating significant concerns regarding protection of constitutional rights. Applicant appellant Willard Miller requests discretionary review and interlocutory appeal from the ruling denying his request to suppression prior to the hearing. They're also appealing to have the warrants and court documents resealed, as well as challenging the judge's ruling to hold Miller's hearings in open court. And since Iowa law allows for pre-trial appeals, they're waiting to find out if the Supreme Court will review the decision. Willard Miller didn't appear on Thursday, March 24th, and his case is on hold pending appeal, but his trial date is now set for November 1st, 2022. By Thursday, March 24th, Goodale's attorney had joined in requesting that the state Supreme Court review the judge's decision, and his hearing was postponed as well. Jeremy Goodale is scheduled to go to trial on August 23rd. If convicted as adults, they face life in prison, but if they're sent back to juvenile court, they'd be released in less than 2 years at age 18. Back to Oxford, Michigan, where the 15-year-old alleged Oxford High School gunman from the November 2021 shooting spree was scheduled for court on March 24th for his monthly detention hearing required by law for a minor who's jailed with adults. Judge Kwame Rowe once again ruled to keep him there, stating, quote, "The court has not been presented with additional information or new information that'll cause this court to disrupt its March 1st, 2022 opinion and order. Therefore, the court will continue the defendant's placement at the Oakland County Jail." The defense also let the judge know during the hearing that the psychiatric evaluations are done, with a report expected in about 6 weeks' time. He'll continue to be held in segregation, out of view and earshot of any incarcerated adults, and he'll continue to only come out of his cell to bathe and accept visits. He's no longer on suicide watch, however, he is monitored by a deputy every 15 minutes. The defense has already filed paperwork stating plans to utilize an insanity defense. Another issue over the previous hearings has been his education and who's responsible for making sure he goes to school, because the prosecution keeps stating that it's the parent's job to provide him with schoolwork. The problem with that, as you may recall, is that for the first time in history, the alleged shooter's parents were arrested too, charged with involuntary manslaughter, and they each pleaded not guilty. The jail is now responsible for the teen's education. All 3 of them remain in the Oakland County Jail together, but separate, of course, and the parents had a hearing on March 22nd, where the judge determined that their son's name won't be uttered at all during their trials at the request of the Oakland County prosecutor Karen McDonald, who said, quote, "Shooters want to be famous. It's one of the key motivators for most shooters, and it was definitely a motivator for the Oxford shooter. He wanted to be famous and he wanted to be remembered. Each shooter wants to be as famous or even more famous than the last shooter. So when we repeat the Oxford shooter's name and continuously publicize his photo, we're contributing to future shootings. I'm not going to be a part of that." Oakland County Circuit Court Judge Cheryl Matthews said that, quote, "There is some precedence but no real legal authority for the mandatory exclusion of the shooter's name. However, calling the shooter by name does not appear to have relevance to these proceedings, and prohibiting its use does not appear to prejudice the defense in any way." Also at that hearing, each were assigned additional independent attorneys to advise them of their rights, because their defense attorneys are partners in the same law firm, and the judge has a, quote, "great concern that there may be a conflict of interest. I'm concerned that at some point, today, tomorrow, next week, a month from now, 4 months from now, that something could happen to cause a conflict that could damage your positions. And I have an obligation to protect your rights. I have an obligation to protect the defendant. I'm concerned as we sit here now, there could be a myriad of things that are incompatible. If there's a mistrial because of a conflict that arises in trial, we go back to square one, and I want to avoid that. I would urge you to listen to them, as this is very stressful for everyone involved, but I'm also trying to avoid having to recreate or go backwards. I'm trying to avoid your rights being implicated in a negative way." For more on the Oxford school shooting, check out episodes 115 and 120, and check back here for updates on the case as they occur. While I was writing this, I thought about what the prosecutor said, and did you notice I didn't mention any of their names? I guess it really can be done. There won't be an episode next week, as I'm off to Los Angeles to shoot a documentary film on the Menendez brothers case. But the week after that, I hope we can look at the alleged role that 17-year-old Linez Escobar of Long Island, New York, also known as Diablita, had in an ambush by MS-13 gang members in April 2017. The trial of Escobar began on Monday, March 21st, 2022, and as soon as that verdict has been reached, you'll hear the story as presented in court. Until then, lovelies, thanks for listening, and don't be scared.